This is a great moment to step up and show all New Yorkers who are going through complexities in their lives that how you must remain focused on your agenda, and that's what I'm going to do. I'm going to step up. I'm not going to resign. I'm going to reign.
What does this mean? Assistance, operation, regulation, giving general opinions? That's illegal? Even hosting an event? It is therefore little wonder that the indictment fails to allege that Adams agreed to take official action. He couldn't. He had no authority to do it. Mayor Adams in New York, not going anywhere, saying resignation? Not happening. In fact, he's filed a motion to dismiss his bribery charges, and he showed up in court and in church to explain that he's not going anywhere. Here's what that sounded like.
Mayor Eric Adams appearing at yet another church this weekend, this morning taking questions outside the Emmanuel Presbyterian Reformed Church in the Bronx.
This is a great moment to step up and show all New Yorkers who are going through complexities in their lives that how you must remain focused on your agenda, and that's what I'm going to do.
The mayor, speaking at the pulpit, said he has no intention of resigning, despite a growing chorus of city voices urging him to do just that.
I'm going to step up. I'm not going to resign. I'm going to reign.
The mayor was asked about the person who could force him out of office, Governor Kathy Hochul. Hochul called the charges a very serious matter, but has not indicated whether or not she'll act to remove the mayor.
We have a great chief executive in this state, and I'm going to continue to dialogue with her throughout this entire weekend and going into next weekend.
Adams pleaded not guilty to federal charges accusing him of taking bribes and illegal campaign donations from Turkish nationals. The mayor's attorney outside court said his client is innocent.
We'll be filing a motion to dismiss. We expect these charges to be dismissed. This case isn't even a real case. This is the airline upgrade corruption case.
Due process. While the attorneys handle the due process, I'm going to handle the management of the city.
It's a good line. It's the flight upgrade corruption case, right? It makes it sound like it's much ado about nothing, because it kind of is, right? This is low-level corruption. It's corruption, no doubt about it, but I don't have in my mind a belief that other politicians are not doing this all the time. In fact, I think it's everywhere in New York. A lot of interesting things happening out of the Southern District of New York. We also have Freak Off Central happening here with Diddy's indictment. We had Ghislaine Maxwell's indictment here. Trump's been prosecuted here. The list has gone on and on and on, although Trump's cases were civil out of this jurisdiction. But Mayor Adams now filing a motion to dismiss. He says this whole thing's a joke. This is it? This is all you've got here? Here's what he says. Now, this indictment in this case alleges a bribery scheme that does not even meet the definition of bribery and doesn't even amount to a federal crime at all. Just 3 months ago, the Supreme Court rebuked the DOJ for adopting, quote, an unfathomable interpretation of a federal program bribery statute 666A1B that, quote, would leave state and local officials entirely at sea to guess about what gifts they're allowed to accept under federal law, with the threat of up to 10 years in federal prison if they happen to guess it wrong. It's like, what the heck? Now, as the court told prosecutors back then, that's not how federal criminal law works. You're not supposed to have to guess about what's legal and not. But here goes the department again. It appears that after years of casting about for something, anything, to support a federal charge against Mayor Adams, prosecutors had finally settled on a theory that depended on the DOJ's longstanding view that Section 666 criminalizes gratuities, including gifts meant to curry favor with governmental officials, but not linked to any specific question or matter, right? So in other words, I'm not being bribed for anything. Now, when the Supreme Court rejected that interpretation in June, prosecutors simply added a few vague allegations and called their theory bribery. Far more serious offense than gratuities, right? It's not about tips anymore. It's now bribery. They said, but they can't just change the words, okay? The concepts are the same. The government's makeover doesn't work. The indictment does not allege that Adams agreed to perform any official act at the time he received a benefit. Rather, it alleges only that while serving as the Brooklyn Borough president, not the mayor, not even the mayor-elect, he agreed generally to assist with the operation or regulation of a Turkish consulate building in Manhattan, where he had no authority whatsoever, in exchange for travel benefits, aka upgrades, to vacant class business seats and a car ride to a restaurant. Oh, they paid for an Uber one time. Great. That extraordinarily vague allegation encompasses a wide array of normal and perfectly lawful acts that many city officials would undertake for the consulate of an important foreign nation, such as arranging meetings with regulators regulators, offering advice about how to navigate the city bureaucracy, and referring diplomatic personnel to attorneys who handle this stuff. Now, although the indictment alleges at one point that then Borough President Adams sent 3 messages to the FDNY commissioner about a building permit that the consulate needed in time for a visit for the president of Turkey, it conspicuously does not allege that he agreed ex ante to take that specific exchange action in exchange for the benefits that he got, right? So the flight upgrades is not connected to any performance of anything specific. That was not a drafting oversight. Okay, they left out that connection because there wasn't a connection. The zealous prosecutors who secured the indictment would have alleged that kind of specific agreement if there was actually evidence, but they don't. And they know that Adams never entered into any such agreement at all. He was being nice and they were being nice, and it wasn't a quid pro quo. And at any rate, even if the government could justifiably allege that Adams had agreed to receive benefits in exchange for assisting with the permitting matter, the 3 innocuous messages that Adams allegedly sent to the commissioner fall far short of any kind of, quote, official act that's necessary for bribery. And so the bribery count should be dismissed. Now, to be sure, the remaining counts in the indictment, which all relate to the so-called straw campaign donations on behalf of the foreign nationals. Remember, they alleged that he was going around and using, buy a table. Hey, you own a construction company. I own a construction company. Can I give you, Mayor Adams, $100,000? No. But why don't you bring 20 employees over here and you can all break it up and give us stuff individually? He says, great. Or other foreigners like Turkish people. Saying all this are meritless. They rest on a host of false claims evidently attributable to a self-interested staffer with an axe to grind. Just one person, which will be revealed in the course of the litigation. With respect to the bribery, the deficiencies in their indictment are clear. The federal rules entitle Adams to a swift dismissal of this charge. Here's the background. They say, all right, listen, in September, the government unsealed an indictment that accuses Adams of getting travel perks and accepting straw donor donations from the Turkish community. They state that there are 5 counts and 4 offenses: conspiracy, okay, wire fraud, soliciting, campaign contributions, and bribery. Now, the allegations supporting a bribery charge are in these paragraphs, 10 paragraphs, and this one, and they relate to a Turkish consulate building in Manhattan known as the Turkish House. Now, for the reasons that are not apparent, they say, says this defense attorney, which I like this attitude here. Perhaps it's just sloppiness. We don't know. Prosecutors can be sloppy. The indictment describes the alleged quid pro quo in 2 different ways. Either 1, Adams accepted travel benefits from a senior official and others in exchange for helping them build this consulate, or he accepted travel benefits in exchange for intending to be influenced in connection with the regulation. Now, despite the fact that the indictment reproduces quotes from messages, emails, conversations, it doesn't allege any specific exchanges or conversations where they entered into this quid pro quo agreement. So it's like a lot of talking in circles. And of course, they say he deleted a bunch of messages. Instead, the agreement is only alleged in conclusory terms, but you don't have the evidence of the agreement. You just have the conversations of what happened before and what happened afterward. Now, the indictment alleges that between the summer of 2021 and 22, Adams solicited or accepted travel benefits. Here are the benefits. In June, he went to Istanbul, free lodging. Then he met with the Turkish official and airport, hotel, and airport lounge. He also got upgrade to Ghana, 9-hour layover in Istanbul. Then he communicated about upgrades for close associates, but they don't allege that he ever took any regulatory action himself. There's a facility that's located in Manhattan. It was outside of his authority entirely. The only actual conduct alleged in connection with bribery is about a building permit, saying that he apparently pressured the New York fired people to issue a temporary certificate of occupancy. Now, this pressure apparently was 3 text messages. This is all he said. He said they needed a letter of defect from the FDNY to the Department of Business, a building. They really need someone by today if possible. If it's possible, let me know and I'll manage their expectations, right? He's saying, I'll let them know. They said the higher ups at the FDNY did not give the inspector authorization to come. The inspector indicated he needs authority to come. And ultimately, they wrote the letter to issue the order. But that's all. He sent 3 messages. That's it. So this indictment must need to fail. An indictment must be dismissed if it fails to allege facts that are even prosecutable. Here, there's no particularity. We don't even know what they're charging. The court should dismiss count 5, the bribery one specifically. The indictment does not sufficiently allege that he got actual benefits for performing the acts. Bribery is punishment if you solicit and you accept anything of value intending to be influenced, but it hasn't happened here. The statute only prohibits bribes, okay, not gratuities. And the Supreme Court does not extend this to gratuities. Gratuities may violate state and local ethics rules, but gratuities don't apply to Section 666. That's for clear bribery, and bribery requires more evidence of bribery. Gratuities come in 2 forms: something given after the fact act as a thanks, something given with a non-specific intent to curry favor. And that's from the DOJ's own manual, you loser prosecutors. And second, like other federal bribery statutes, federal program bribery requires the defendant to agree to perform an official act. That's what SCOTUS has said. Indeed, even 3 dissenting justices agreed that the statute requires some official act. Even Justice Jackson said, yeah, it does criminalize bribe, but we haven't been really clear on what a bribe requires. She called it a quid pro quo, which means in exchange for an official act. That is not here. Accordingly, the Second Circuit has said that an official act standard does not apply to 666. And under the first requirement, setting up a meeting, hosting an event, or calling, so they're going to give us 2 different interpretations of this and say none of them meet this. Simply expressing support for a course of action is not a quid pro quo. And under the second requirement, as even the Second Circuit said, at the time the bribe is made, the official act must relate to the bribe, which hasn't happened here. These 4 requirements rest on the Constitution. For that reason, even if the contours of an official act differed, it doesn't apply here. This court should dismiss bribery because the indictment does not even allege a quid pro quo, just saying they did a bunch of nice things for each other. It alleges only that Adams agreed to assist in the operation. By their words, their charging words. That's it? Assist in the operation? Those vague allegations don't identify any concrete or specific exercise of governmental power at all, and they would at any rate encompass a variety of routine activities that don't qualify as official acts anyways. Setting up meetings, relaying information. The only specific acts in the indictment that they allege are 3 messages that Adams sent for the purpose of getting the FDNY to get them a fire approval. The indictment doesn't allege the sine qua non of bribery, which is the key element, the solicitation or acceptance of something of value in exchange for an official act. And so anything else is alleged is just too vague and it's too broad. The factual allegations state vaguely that Adams agreed to accept travel benefits like seat upgrades and car rides in exchange for assisting Turkish people. The indictment statutory allegations state somewhat inconsistently, but also vaguely, that the agreed upon act was some unspecified activity. Don't even know what it was. They're too general. They don't specify specific and focused crimes that allow you to even defend them. And even if those allegations were specific, what does this mean? Assistance, operation, regulation, giving general opinions? That's illegal? Even hosting an event? These deficiencies in the government's allegations are deepened by the fact that the indictment minimizes that Adams was not even the mayor. He was not even the mayor-elect when this Turkish house stuff was going on. He was a Brooklyn borough president. As the indictment itself makes clear, Adams had no authority with respect to the consulate. The building's located in Manhattan, not even in Brooklyn. Although Adams was a candidate for mayor at the time, a mere aspirant to public office cannot exercise the powers of that office. He had no jurisdiction to even engage in the quid pro quo. It is therefore little wonder that the indictment fails to allege that Adams agreed to take official action. He couldn't. He had no authority to do it. Now, accordingly, the alleged agreement here, travel benefits in exchange for assisting with the operation, is insufficient to support federal bribery. And so the indictment does not even allege that he agreed to influence the building permit. They say he accepted upgraded tickets and he obtained his fundraising travel perks, but the indictment doesn't say anything about accepting that in exchange for anything specifically. And the permit matter didn't even arise until later. So those benefits were clearly not in exchange for that thing. They were just nice favors that everybody was doing for each other. So it's insufficient to say this is an official act. It was currying favor. It's a gratuity. It's not a bribe. And so the indictment also alleges that after the permit matter was resolved, Adams got another upgrade and a 9-hour upgrade, but he got that after the thing. So again, it was not connected. So nowhere in the indictment does it say that Adams agreed to take this in exchange for a specific benefit. To be sure, the lead-in paragraph to the factual allegations related to the bribery count states that Adams intervened with the FDNY, but it's clear from the specific allegations that it was only a general agreement. There was no any specific agreement about the permit, not even arisen yet, and without any other promise to intervene, there's simply no bribery. Were it otherwise, elected officials who make promises to donors to assist on broad policy objectives, like reducing regulatory red tape or anything else, they could all be liable for bribery. That's not right. Now, finally, the indictment says that Adams took additional actions in exchange for travel benefit, but only identifies one: putting the general manager of a Turkish airline on a transition committee. We remember that. But the indictment does not claim that the exchange was related to regulation of the Turkish house, and so doesn't fall into any of the criminal counts. At any rate, the indictment does not explain how the mayor-elect's appointment of a private citizen to a transition committee is a governmental power problem or the use of an official position at all. So beyond that one allegation, the indictment generally alleges that Adams continued his agreement with this Turkish official, but they don't say he took any action alone at all in 2022. The The only claim is that he said something like, all your pending problems with that building will help you with, but no allegations that they actually acted on anything. It's way too generalized, and so it's not bribery. In short, the indictment alleges only that Adams agreed to accept benefits in exchange for operations or regulations of the Turkish house. And so there is no official act element of bribery there, and so count 5 has to go. Now, the mayor's messages to the commissioner were not even official acts. Even if the indictment had adequately alleged an agreement for Adams to receive benefits, the 3 messages are not an official act. There can be no question Adams did not even direct himself to open the place. None of the messages order them to do anything, nor could Adams have done so, okay? He was the Brooklyn Borough president. He had no regulatory power over the FDNY at the time. And while the indictment asserts that he had authority under the New York City Charter to affect the administration, the generic examples that it provides have nothing to do with the FDNY, much less the permitting process. And so given that Adams lacked any actual power, he did not exert pressure because he couldn't. None of Adams' messages remotely convey any threats. He was trying to figure this out. A reasonable fact finder could construe that the statements were not official to do anything. There were no threats, no emphatic language at all. He indicated that it was urgent, they really need something done today, but it's not official. He made it clear he was not pressuring them. And so there is accordingly nothing about this case to distinguish it from any situation where an official raises an issue with another official who's not under his control. Happens every day. So we can't call this political pressure. Adams made non-committal responses. The indictment alleges that the commissioner himself threatens that subordinates would lose their jobs, but that's not Adams making that threat. If the commissioner's making that threat, that's not Adams. And so this pressure theory is from the government. They're effectively claiming that Adams used his, quote, potential future position because they knew this guy might be big in New York politics, but that's not official. Although Adams happened to be running for mayor and was maybe likely going to become the mayor, he still wasn't. The bribery count suffers from fundamental problems that have long plagued the DOJ's aggressive targeting of prominent public officials. A sweeping view of federal statutes that criminalizes routine conduct and replaces ethical rules with criminal law. The consequence is a lack of fair notice to the defendants of a highly selective enforcement on display here. The court should dismiss the bribery count for failure to allege a crime. Great motion from Alex Spiro and William Burke. And that's a good one. And I think this is exactly right, actually. The indictments that we've been seeing out of the Southern District of New York have been crap, honestly. The Eric Adams indictment was garbage. What? Like flight upgrades? That's what you're getting this dude on? Every politician is doing straw donors in America. Just look at Act Blue. Mostly fake. So why did they come after Adams? Even the Diddy indictment is mostly a joke, and I'm sure they're going to expand that maybe with the superseding indictment at some point. But you're going back to 20, 30 years for Diddy, calling it a conspiracy case for trafficking an adult prostitute across state lines, like adult people. That's the indictment. Now, at the freak-off parties, there are much worse allegations happening there, but it's not in the indictment. Some of it is, but not as charged conduct, as criminal charges. So the SDNY is strange jurisdiction, and Adams filed a very good motion to dismiss, and we're looking forward to seeing what the prosecutors say in response to this, but we'll keep our eye on it. Thanks for subscribing, as we do.